by 2030 will become the largest consumer market in the world with gross domestic product growth rate of 7.6%. Now, Consumer Protection Act 2019. So let me tell you, friends, that why a need was felt on the part of the government of India to replace the old act. For the simple reason that the old Consumer Protection Act 1986 was not standing test of the time in terms of various challenges, in terms of the digital economy, the online buying, selling, e-commerce, digital economy. And therefore, a desperate need was felt on the part of the government of India, and the government of India ultimately brought in this new legislation, which is known as the Consumer Protection Act 2019. On 9th of August 2019, President, Honorable His Excellency, the President of India, gave its assent to this law, and this became the law thereafter. And this new law of 2019 came into force with effect from 20th of July 2020. So let us now move on to the next slide. Objectives of Consumer Protection Act 2019. So you can be asked as to what are the objectives to be achieved by this new legislation. So the primary objective of this new Consumer Protection Act 2019 is to protect naturally consumers' interest, consumers' right, and to establish a robust system for the settlement of consumer disputes. The objective of 2019 Act is to protect consumers by establishing or setting up authorities under the 2019 Act for timely and sufficient administration and settlement of consumer disputes. In due course of time, a little later, I'll be dealing with these authorities in the subsequent slides. ये दिखता ही नहीं है इसके ये क्या है इसका हेडिंग जो होता है ना चलो ठीक है. Now friends, this is our next slide, and in this slide I have tried to tell you about the various rights of the consumers. So what are the rights of the consumers which have been granted to consumers under the new 2019 legislation? So first of all, I would quote the relevant section of the law, that is section 2 clause 9 of the Consumer Protection Act 2019, that is specifically lists 6 very, very important and valuable rights of the consumers. So let us now have a look at all these 6 rights of the consumers. So you must know what are these rights of consumer, because we all are consumer. So first right which has been granted under this act to consumer is the right to be protected against marketing of goods, products or services which are hazardous to life and property. So if you find that a product, good or service is found to be hazardous to your life or property, so you have been granted a right to be protected against these hazardous goods and products or services under the act. Second, consumers have been granted the right to be well informed about the quality, quantity, potency, purity, standard and price of goods, products or services, so that they can protect themselves against unfair trade practices. The third very valuable or important right is that the right to be assured wherever possible access to a variety of goods, products and services at competitive prices. Suppose I tell you one example. You go to a clothes shop for buying some clothes and the shopkeeper only displays you a particular quality of cloth which is very costly. However, the fact remains that he is also having other kinds or other quality of clothes of lesser value, but he does not display these lesser value of clothes to you. In that case, you have a right to approach the right authority, and you can tell the shopkeeper that now under the law you cannot hide the items of lesser value or good quality. So the right to be assured wherever possible access to variety of goods or products and services at competitive prices. Let us move on to the next. The fourth right that has been granted to consumer is the right to be heard and to be assured that consumers' interests will receive due consideration at all appropriate fora, be it district forum, district commission, state commission, national commission, or any other authority under this 2019 Act. The consumer interest will receive due consideration before all the authorities or before all the forum. Then the fifth right is the right to seek redressal against unfair trade practices or restrictive trade practices or unscrupulous exploitation of consumers. So now, after coming into force this new legislation, new law of 2019, you can seek redressal against any kind of unfair trade practice, against any kind of restrictive trade practices, or even against your exploitation. So as I told you at the very inception that ग्राहक को भगवान माना जाता है, भगवान को भी यहाँ ठगा जाता है. Now it will not be possible anymore. After coming into force of this 2019 legislation. And the last right, the sixth right under the Consumer Protection Act 2019 is the right to consumer awareness. This is very important right that has been granted or that has been conferred on the consumer. Right to consumer awareness. So you as a consumer is also having your valuable right to consumer awareness about the quality of the of any goods, service or product. So these are the six very, very important and valuable rights of the consumers. Now, who can file complaint under 2019 Act? Why this patti is coming in?
Sir, we may reduce.
Because I can't read it.
No problem, sir. I need to please shift the slide.
वो तो कर दिया मैंने. ये ऊपर का heading गायब हो गया.
No,
आप लोग पढ़ पा रहे हो?
yes.
ऊपर का heading. हाँ, आप तो पढ़ पा रहे हो. ये मुझे.
Yes.
Yes, who can file complaint under 2019 Act? This is very, very important. You can be asked even in your examination who can file complaint via under 2019 Act. Naturally, the answer is a complainant can file a complaint under this new legislation of 2019. So let us now understand who is this complainant who is entitled to file a complaint under this Act. So section 2 clause 5 or subsection 5 defines the term complainant. It includes complainant means a consumer. Simple. We all are consumer. because we are day in and day out buying products, services, goods, then a complainant may be any voluntary consumer association. So there are now n number of voluntary consumer association. They, on behalf of consumer, or if there are more than one consumer, jointly file the complaint. So any voluntary consumer association is also a complainant under the Act of 2019. Then third is the central government or any state government can also file a complaint. They can also act as complainant under the Act. So specific rights have been given to central government to file the complaint as well as to the state government. Then the third is the central authority. I will deal with the central authority, the concept of central authority a little later. This is one of the most important authority under the Act. And I would say that this is the regulator under this Act, regulatory body. So central authority can also file a complaint. Then fifth is one or more consumers, where there are more than one consumers and they are having the same interest. In that case, they can jointly file the complaint. Then sixth, in case of death of a consumer, suppose a consumer has died, what will happen? Who will file the complaint? Naturally, after his death, his legal heir or his legal representative is entitled to file the complaint on behalf of the dead consumer or deceased consumer. Then lastly, in case of a consumer being a minor, and if a consumer is a minor, naturally minor can't file the complaint. So his parent or legal guardian can file a complaint under this Act on behalf of the minor consumer. Where complaint can be filed. So we have understood who all are complainants under the Act. Now the question is where this complaint can be filed. This is the slide you can see. So friends, as you can see that the 2019 law gives 4 options to a complainant to file his complaint, his or her complaint. And section 34 clause 2 provides these 4 options to the complainant. So if you want to file a complaint before the district commission, how you would file this complaint before the district commission? So it says that in a district commission, within the local limits of whose jurisdiction the opposite party or defendant, I mean to say opposite party means defendant, or each of the opposite party, where there are more than one opposite party at the time of institution of your complaint, ordinarily resides or carries on business or has a branch office or personally works for him. So it says that you can file the complaint in the district commission in whose jurisdiction, local jurisdiction, all your defendants are residing ordinarily or carrying on business, or they have a branch office, or they are personally working for gain. The second option is that any of the opposite party where there are more than one at the time of the institution of the complaint actually and voluntarily resides or carries on business or has a branch office or personally works for gain, provided that in such case the permission of the district commission is given. So here suppose, so in the first option, all the defendants were residing or personally working for gain in one particular area or district. Then you could have filed the complaint before that district commission. But suppose there are more than one opposite party, and out of them, one opposite party or defendant is residing or personally working for gain in some particular area, so you can file that complaint in the local jurisdiction of the district commission where that one defendant is residing, provided you will have to obtain due approval or permission from that particular district commission. Let us move on. Second, the third option which has been given is where the cause of action wholly or in part arises. So you can file your complaint where the cause of action either wholly or in part arise. What is cause of action? Cause of actions are basically the set of facts which ultimately lead you to file the complaint. It means these are the facts you feel aggrieved. They give you the reason for the litigations. This is known as cause of action. So wherever cause of action, you can file complaint there. The last option and the very, very important option and the most forward-looking approach under this law is that now you don't need to go anywhere as a complainant. Wherever you as a complainant or consumer residing or personally working for gain, you can file the complaint where you live, where you reside. So this is the most empowering provision that has been introduced by this new legislation, empowering the consumers. So you can now, you just skip all these three options. You only keep this last option in your mind, that a complainant naturally on his own accord would like to file the complaint wherever he is residing. Naturally, he would not like to go to Bombay. Suppose he has purchased the item from or some products from the Bombay. Would you like to go to Bombay to file the complaint? No. Now, this is the nicety or beauty of this law, which has granted you, and this is, I tell you, this is a game changer, a phenomenal provision which has been added, which has been introduced in this new law. And I have added one note also. You can file your complaint offline as well as now you can file your complaint electronically as well. So you don't need to go to the authority and file offline complaint. You can, sitting at your residence, file your complaint electronically also. So this is the beauty of this law. Oh, yes. Now we have understood the complaint, who is a complainant, where the complaint can be filed. So let us see who is a complainant then. Complaint, sorry. Who is, what is a complaint? Problem, I can't read it. ऐसा क्यों हो रहा है इसमें? You can see. So the next slide is, what is a complaint under 2019 Act? So you need to understand as to what is complaint. Let us see. So section 2, subsection 6 defines the term complaint. Let us see what is complaint. Complaint means any allegation in writing made by a complainant for obtaining any relief under the Act. So it simply says that complaint is an allegation, but it should be in writing, which you are filing or making as a complainant for the purpose of obtaining relief under the Act. Now, what may be these allegations under your complaint? Or I would like to say as to what grounds or allegation should be taken by you in your complaint when you act as a lawyer. So the allegation that an unfair contract or unfair trade practice or a restrictive trade practice has been adopted by any trader or service provider. This is one allegation that can be taken in your complaint. The next is the goods bought by him as a consumer or agreed to be bought by him suffer from one or more defects. So you can take this averment or ground or allegation that the goods which you bought are defective or the services you bought are deficient. The services hired or availed of or agreed to be hired or availed of suffer from any deficiency. So goods are always said to be defective, services are always said to be deficient. Then fourth, a trader or a service provider, as the case may be, has charged for the goods or services a price in excess of the price ABCD, what fixed by or under any law. So if you approach a trader, a shopkeeper, and if he is charging price which is in excess of the price that has already been fixed under a law or displayed on the goods, so you might have seen many times that the goods itself show the price on the back of the product. If the trader or the seller is charging you a price in excess of the price which is being displayed on the product itself, he cannot be allowed to do so. This may also be an allegation in your act. He did so. He charged excess price. It was excessive because the price which was already being displayed on the product itself, it was not matching up with that price. Thirdly, displayed on the price list. So you might have seen that many shopkeepers have the price list. And when you are aware, you ask for the price list, and he, under law, under an obligation to exhibit or display that price list. And if the trader or seller is charging you a price in excess of this price, which is already exhibited under the price list, excessive, then he cannot do so. Or lastly, agreed between the parties. If you have agreed, there is an agreement between you or the seller with regard to any price, and if he violates that agreement, then you can take this allegation in your complaint. So this was about the as to what is a complaint. Fifth, yes, now you can also take an allegation in your complaint that goods hazardous to life and safety are being offered for sale. There is a trader or shopkeeper in my neighborhood, he is selling or offering for sale such product which is hazardous to life and safety. So you can take this allegation in your complaint. Then services hazardous to life and safety are being offered for sale can also be taken as an allegation in your complaint. And lastly, a claim for product liability action can be taken in your complaint which lies against the product manufacturer, product seller, or product service provider. I will let you know what is this product liability a little later. Now, the most important aspect which now I am going to deal with, you will find on this screen who is a consumer under the 2019 Act. So the term consumer is defined by Section 2, Clause 7 of the Consumer Protection Act 2019. And it says that a consumer means who buys any goods for a consideration which has been paid or promised or partly paid or partly promised or under any system of deferred payment, and includes any user of such goods other than the person who buys such goods for consideration when such use is made with the approval of such person, but does not include a person who obtains such goods for resale or for any commercial purpose. Let me explain you this particular definition. I'll try to explain this by giving you one simple example. Suppose you buy a laptop from a company. You buy this laptop from a company for being used by your daughter. Okay, so you have bought this laptop, but you are not going to use this laptop. It will be used by your daughter or by your son. So here, who is a consumer, right? Naturally, who has bought the item, the product, he is the consumer. But this is the most forward-looking provision or the definition under this new 2019 Act that has widened the scope of definition of consumer. Now your daughter or your son for whom your father or you have bought that laptop, she or he will also fall under the definition of consumer. She will also be a consumer. He will also be your daughter or son will also be a consumer. So here, not only you who has bought some item for some consideration, it is also the person who is going to use that product. तो अब आपने खरीदा, लेकिन आपके किसी भाई ने या आपके बेटे या बेटी ने अगर उसको यूज किया, तो वो सभी आपके साथ साथ आपका बेटा बेटी भी कंज्यूमर की डेफिनेशन में, परिभाषा में शामिल हो जाएंगे. तो ये आपको समझ लेना चाहिए. और ये दिस इज द मोस्ट phenomenal change that has been incorporated and introduced under this new 2019 Act. Earlier it was not so. Under the old Act, the definition did not extend to the user, but now even the user will also be a consumer. But provided, yes, let me again clarify that you are buying that product for some consideration. Yeah, here consideration means you are paying price. Consideration means paying the price. That is known as consideration and under law. Then again, let me clarify that you have bought this laptop not for any commercial purpose. Yes, if you have bought this item, that is the laptop, for any commercial purpose, then you will not be treated as a consumer under the Act. So it should not be for the purpose, for commercial purpose. I think you have understood it. Let's move on. Then second is hires or avails of any service for a consideration. So we are discussing the definition of consumer. Earlier it was with regard to a goods or product. Now it is relating to services. So one who hires or avails of any service for a consideration, I mean for a price, which has been paid or promised, or partly paid or partly promised, or under any system of deferred payment, and includes any beneficiary of such service other than the person who hires or avails of the services for consideration, but does not include a person who avails of such service for any commercial purpose. This is the same thing. You should apply the first option relating to goods to the second option. If you are hiring service, then the same thing will apply. Okay. Even the user of that service will be treated as a consumer, and it should not be for any commercial purpose. If it is for any commercial purpose, you will not be a consumer. Now there is an explanation appended to this section with regard to the definition of consumer, and the expression commercial purpose does not include use by a person of goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. So this commercial purpose has been further explained, and I'll give you one example. Suppose you are a small scale vegetable vendor and you go to a big agriculture, vegetable trader. You buy the vegetables and then you sell these vegetables on a thela, moving from one colony to another colony. So this is what? This activity is not being done by you for any commercial purpose. You are selling the vegetable for earning your livelihood. So here, if whatever you are buying is further to earn your livelihood, then in that case, it will not be considered as a commercial purpose, right? Same thing, it applies to services. Now, product liability, a new concept, a very forward-looking concept, and this is defined under section 2 subsection 34. What is product liability? The word, the term itself says liability related to your product. So let us see. Product liability means the responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to a consumer by such defective product manufactured or sold, or by deficiency in services relating thereto. So product liability simply means the responsibility of the manufacturer, the responsibility of the seller with regard to any defect in product or deficiency in service. Now, product liability action. What is this product liability action? Product liability action simply means the complaint which you file for the product liability either before a district commission or a state commission or a national commission, as the case may be. Consumer protection councils. This is another a very forward-looking approach under the 2019 Act. Under the old Act of 1986, no such councils were there. This is the first time that these consumer protection councils have been set up. So chapter 2 of the 2019 Act thoroughly deals with all these consumer councils, and there are three kinds of these councils. Central Consumer Protection Council, which will be established by the central government through a notification. Then the State Consumer Protection Council, which will be established by the state government through a notification. And there will be a District Consumer Protection Council, which will be established by the state government through a notification. And friends, these are basically the advisory bodies or advisory councils under this Act. The objects of these councils, central, state, and district, shall be to render advice. So these councils, what is the function? Their basic duty or function is to advise on promotion and protection of the consumers' rights and their interests under this Act within their respective jurisdictions. So these councils basically act as advisory councils under this Act. So their function is only to give advice. Let us see the most important authority under the Act. Central Consumer Protection Authority, also known as CCPA, and also known as Central Authority. Section 10 provides for the establishment of this central authority or Central Consumer Protection Authority. This Central Consumer Protection Authority or CCPA will be established by the central government with effect from such date as this central government may specify in the notification. So it is also known as central authority. And let me tell you, friends, that this is the first time under this law, this CCPA, which is also known as central authority, has been set up, and it is the main regulatory body under this act. Under the old act, there was no regulatory body under the 1986. So this is the first time this regulator has now been appointed by this law known as CCPA or Central Authority. And let me tell you, you might have heard TRI or SEBI. These are also regulatory bodies. So when you appoint some regulatory body, then the implementation of the law becomes very easy. The regulation of the provisions of that particular law becomes very easy. So this is the first time that central authority as the main regulator has been appointed and established. Now let us see what are the objectives of this central authority. To regulate matters relating to violation of rights of consumers, to regulate unfair trade practices, false or misleading advertisement, which are prejudicial to the interests of public and consumers, to promote, protect, and enforce the rights of consumers as a class. Well, let me tell you, or let me share with you a few examples of misleading advertisement and how the CCPA acted against those misleading advertisements. So I'll share with you these examples of certain companies, especially during COVID-19 era. So you must have heard the name of this company, Asian Paints. We usually use Asian Paints in our home to decorate our houses. So actually, this during the COVID-19 era, what happened or period, what happened, this Asian Paints made a claim that its Royal Health Shield paint is effective against coronavirus. It was naturally an outlandish claim. Complaint was filed against the Asian Paints. The CCPA or the Central Authority acted against this Asian Paint, issued notices to Asian Paint and imposed fine. And ultimately what happened, the Asian Paint had to withdraw this kind of outlandish claim in form of this misleading advertisement. And you must be seeing day in and day out Mountain Dew ad in your television, which is being played by Hrithik Roshan. Oh, what is this? He is just having Mountain Dew and becomes so confident that he tries to display the daredevilry. So is it possible? Certainly not. It also falls under the category of misleading advertisement, and someday this Mountain Dew may also have to pay price for this misleading advertisement. What is this Fair and Lovely? You will just apply Fair and Lovely, you will become, you will get fair complexion, and then you will become confident. Is it possible? This is just an outlandish claim. This is a misleading or false advertisement. And I tell you, friends, that there are n number of examples of such companies against which Central Authority or CCPA has very effectively proceeded against and imposed a fine. And these companies had ultimately stopped these misleading advertisements. So now this is the time, and this is the most forward-looking or most empowering law. Now no such companies can indulge into such misleading advertisements. Now, again, wake up, customer, wake up, jago, grahak, jago. This is the, again, one very important object of central authority. And basically, this is what this is jago, grahak, jago is a leading awareness, consumer awareness campaign, which is being run throughout India by CCPA to make consumers aware of their rights and their interests. So chapter 3 thoroughly deals with this, the provisions with regard to Central Consumer Protection Authority or Central Authority. Now, the most important part again is the Consumers Dispute Redressal Commission. So friend, let me tell you that this is a 3-tier adjudicating mechanism that has been provided under the new act. However, it was also there under the earlier or old act of 1986. But now these commissions have been granted much more power just for the purpose of settlement of disputes. And I'll let you know what are the various powers of these commissions. So, district commission to be established by the state government. A district commission shall be established by state government under notification under section 28. That under section 42, state commission shall be established by the state government. And under section 53 of the Consumer Protection Act 2019, national commission shall be established by the central government. And popularly, you can call them consumer courts in the country or hierarchy of consumer courts. So these are the 3-tier or 3 layers of adjudicating mechanism: district commission, state commission, and national commission. Now let us have a look at the pecuniary jurisdiction which these district, state, and national commissions are having. So district commission has a jurisdiction to entertain a complaint up to ₹1 crore, section 34. So if you want to file a complaint with a monetary claim up to ₹1 crore, you will file this complaint before the district commission. You can't file this claim or this complaint before the state commission. So state commission is having a pecuniary jurisdiction of more than 1 crore. So if your claim exceeds ₹1 crore, then you can approach the state commission. Up to 10 crores, state commission can entertain your complaint. And if it is above or more than or exceeds ₹10 crore claim, then you have the only option to approach directly to the National Commission under section 58. So these pecuniary jurisdiction or pecuniary limits have now been revised under the new act, and the limits have been enhanced. Earlier, these limits were not of this level. Now, the orders or the legal remedies by these redressal commissions, what kind of orders can be passed? What kind of remedies can be given by these redressal commissions to a complainant or to a consumer? So let us have a look at. First, a redressal commission can order removal of defects from the goods in question. You better remove these goods. Or it can order replacement of the goods. You have to replace these goods. It can order refund of price. It can award compensation. It can order removal of deficiency in service. It can also order discontinuance of unfair or restrictive trade practice. It can order to stop the sale of hazardous goods. It can withdraw the hazardous goods from the market. It can order payment of adequate costs to the victims. And it can also order to stop any misleading or false advertisement. Now, what will be the limitation period for filing this complaint before these commissions? So it has been specifically mentioned under section 69. 69 provides for the limitation period for filing of complaint before the district, state and national commission, and this is 2 years, within 2 years. So you should be aware of this fact that there is a limitation period is specifically fixed under the Act. If you are feeling aggrieved with any defective or deficient product or service, you are required to file your complaint within a period of 2 years from the date on which the cause of action has arisen. So whenever you suppose you have bought this laptop and you find the laptop defective, the day you discover that this is defective, that day gives you the cause of action. And from that day, you are required to file your complaint within a period of 2 years. And if you fail, then it is up to you. Choice is yours. Now, another most important and forward-looking approach of this new 2019 law, Consumer Protection Act 2019, is the mediation, the ADR mechanism. So ADR mechanism has been introduced for the first time under this new law. And through mediation, these district commission, state commission or national commission, if these commissions find that elements of agreement or compromise exist between the parties, the commission can order both the parties to go for the settlement of their dispute through mediation. So mediation is basically an ADR mechanism, which is a very forward-looking approach. And today, as you know, big business houses, big traders don't like to get involved in litigation. They would better like to settle their disputes out of court. So this is for the first time that mediation has now been introduced under this new law. And really, this is most empowering and phenomenal change that has taken place under the new law. Chapter 5 thoroughly deals with mediation process. Now, offenses and penalties, lastly. Chapter 7 deals with offenses and penalties, and section from section 88 to section 93 provide for the offenses and their penalties. So I have skipped many more things under offenses and penalties. I have only incorporated what is most essential. Otherwise, you see, looking to the paucity of time, I have to wrap up this session within the time limit I was given. So if the direction of central authority, CCPA, which we have just discussed a few minutes back, under section 20 and 21, is not complied with by a person, shall be punished with imprisonment for a term which may extend to 6 months or fine which may extend to 20 lakhs rupees or more. So everybody who is given a direction by the central authority under section 20 and 20. What are these section 20 and 20? They are related to misleading advertisement and recalling of the defective goods from the market. Central authority has got power to recall the goods which has already been circulating in the market. So central authority can recall those goods by directing the trader or seller or the manufacturer if they are found to be defective. And section 20 is with regard to misleading advertisement. And if suppose a direction has been given by the central authority under these two sections, if they are not complied with, then they will have to face the music of law. 20 lakhs rupees, 6 months fine, 6 months is the imprisonment, 20 lakhs rupees is the fine, and both may be imposed. The punishment for false and misleading act, maximum sentence is 2 years, maximum fine of 10 lakhs rupees. Suppose there is a subsequent offense or offense is repeated, then the sentence will be 5 years of imprisonment and fine of rupees 50 lakh maximum. So this was all about our today's session. I think I have exceeded already my time. So I have wrapped up, friends. If you have any question, you can ask.
Thank you, Dr. Joshi. Somebody has asked some question. I think we should go and check the chat box so that we get idea on the questions. Somebody has asked, what is the link to file a complaint from home, please?
No, that you will find online. Just go consumer online filing. Sanjay Chaturvedi has asked, what is the link? Sir, you will find when you will search on Google, you will find it. Even I have not tried it. So you go Google it and you will find it online. No issue at all.
Yes. This is the beauty. I understand that Dr. Joshi has elaborated each and every issue and incorporated all the things along with the examples to make all of us understand. And the basic idea, the basic aim of this webinar is to generate ideas. At least we all, the genuine people, may get an idea what to do, what not to do, where to go, where not to go. And still, if you have any query, you may please forward through chat so that we can raise the question to Dr. Joshi. Bhatnagar Sahab, welcome and thank you very much for your blessings. Very useful talk, and by the grace of God and your blessings, will keep on conducting such type of activities. Thank you. Thank you. Sometimes consumers misuse their rights. So what do you think about the scenario? Pooja Jain has raised this query. Dr. Joshi. Next to Bhatnagar Sahab.
Yes, sometimes consumer misuse their rights. So what do you think about that scenario? Nothing. They will not be getting any relief under the act. As simple as that. Only the genuine consumer will get the relief. You should keep this fact in mind that law is very, very clear, crystal clear. No fake consumer will get the benefit under the new act. It is only the genuine complainant, genuine consumer. If anybody is naturally misusing or abusing their rights, then he will not be getting the relief. As simple as that. Yes.
Dear friends, we have.
Thank you so much, sir. Sir, can I speak?
Yes, Pooja.
Sir, actually, there is one question. I don't know if this comes under Consumer Act or not, but हम सब friends, like we 4 or 5 friends, went to a restaurant जहाँ पे we order French fries. Okay, वहाँ पे mistake मेरी friend की थी because उसने अपने hairs को open रख रखे थे and उसका ही बाल वहाँ पे गिरा था उस French fries में. But what she did ना, उसने उस चीज का राई का पहाड़ बना के and another French fries we.
Yes, I can understand. So basically she misused the situation. But let me
exactly.
Yeah.
Sir, can I ask one question, sir?
Sure. Welcome, sir.
If I'm not exceeding the time limit, if sir would permit me.
Not at all, sir. You are free to ask them.
Yeah, thank you, sir. Thank you, sir.
Yes.
I am Dr. Prashant Nahar. I am basically a practicing dental surgeon and I am faculty from Pacific Dental College. Sir, I would just like your attention to 2 or 3 questions. One is related to the legal redressal forum mechanism. Now, sir, since we are facility providers or the service providers to our clients, and most of the times what we read in newspapers is कि किसी patient ने किसी doctor के medical procedures के खिलाफ उसने consumer forum में कंप्लेन की है और कंज्यूमर फोरम ने इतने लाख रुपए का उसको कंपनसेशन दिया है, तो मैं चाहता हूं कि क्या ये कंपनसेशन का ऑर्डर देने से पहले क्या ऐसा कोई मैकेनिज्म है जिसमें करेक्शन ऑफ द डिफेक्ट किया जा सके?
Let me clarify, Dr. Prashant ji, कि under this new 2019 law, medical services still have not been included. There is a definition of services, and if you will go through the definition of services, you will not find mention of medical service. So how would you file the complaint against a doctor in that case if it is not included?
But sir, orders are passed in the court and we read about them in our newspapers every day, off and on.
What was the date and year of filing of that complaint?
नहीं, मैं जनरल बात पूछ रहा हूँ कि जिसमें आपने जब रेड्रेसल फोरम के जो डिफरेंट प्रोसीजर्स बताए हैं.
I have understood. These days the law is still, it is very clear. Right now, medical services have not been included under the services under this new law. So if you are feeling aggrieved with any medical services, maybe a government medical hospital or private hospital, in that case, you cannot approach these redressal commissions because you have specifically excluded as a medical professional out of the ambit of this law. This is my question. This is my answer to your question.
Then how these laws are being, these orders are being passed against doctors, sir, for compensation?
You can file there are various other legal remedies available to you, bhai.
Okay.
They are filing, let them file, but under the new law, they can't file. I am telling you the legal position.
Okay, sir.
Yes,
So
under the old act, let me clarify. Under the old act, Consumer Protection Act 1986, yes, complaints were filed against medical professionals, doctors. But yes, you file, since this is a law and law is always changeable. And if the court suppose order, even suppose the Supreme Court passes an order to the effect that the definition of service must include the medical profession, in that case, yes, you file as a, it will be just a practice. If you file any complaint against a doctor, let us see what happens. Just try the water, test the water.
Okay, sir. Thank you, sir. One more small question. आपने एक बताया था cause of defect का, जिसका हम 2 साल के अंदर फाइल कर सकते हैं, period of filing the complaint. So does that, if it is that period of the cause of effect time is within the guarantee period, then if the company is ready to compensate for that, then is it respect?
See, if the company is ready, suppose you have approached the company for redressal, naturally you don't file complaint directly. First of all, what you do is you approach the company concerned and you ask for the damages. And if the company is ready and willing to compensate you, in that case, you don't require to approach the commission.
Okay.
Yes.
Thank you.
Is there any other question?
Any more questions from anyone? Okay, so we wind up the session by complimenting and accord a big thank to Dr. Manoj Joshi, who has made us clear with numerous things on consumer protection, under which we were not aware, despite the fact that we all are academicians. industry people, doctors and all. And still the talk is very, very useful for all of us. This I presume and assume also. And we are always ready to organize, to conduct this type of events quite often. So if you have any suggestions for the next topic, we are always open. With this, I thank Dr. Manoj Joshi and the entire team of PSL for the nice show shown today, along in association with the ISTD Udaipur chapter. Professor Dipin Mathur is there, and he is a great support to all of us. So I accord a big thank to him also. And we wind up with this, that we'll be meeting soon somewhere on this type of activity in future also. Thank you.